In almost every country that has been touched by the coronavirus pandemic, there has been an increasing wave of uncertainty in dealing with contractual disputes and the performance of contracts that have been affected. COVID-19 has shown us that the performance of a contract may become either physically or legally impossible by one party, resulting in a breach of contract. However, this impossibility may actually only be temporary. Even if performance remains possible, one party may find it much more expensive to perform, or the other party may no longer have any use for the goods or services that has been supplied. Therefore, how can parties maintain their needs and obligations at a fairly equal standard? How might they be able to minimise legal disputes and salvage relationships in unforeseen circumstances? As part of its response to the coronavirus pandemic, the UK government issued guidance on the 7th of May 2020, strongly encouraging contractual parties to adopt a more conciliatory approach to avoid and/or minimise protracted legal disputes without prejudice or altering parties' legal rights. Not only has the BICCL recognised that English law is blunt, and it does perhaps require some flexibility, it has done so by alluding to the principle that seems to have gathered ever-growing frequency in recent case law, the principle of good faith. The remainder of this presentation will aim to discuss whether it is now time for English law to embrace the duty of good faith in the performance of all contracts. By doing so, I'll outline what good faith means, its current standings within English law through implied and express terms, and to conclude why this principle is beneficial within the performance of contracts. The principle of good faith, unlike in many jurisdictions of Europe, such as Germany, which implies the duty of good faith in both the performance and negotiation of contracts under Section 242 of the BGB, and in France, which has this implied duty in the performance of contracts under Article 1134 of the Civil Code, it is not a recognised doctrine in English law. It could be said, therefore, that English law has backed itself into something of a corner in relation to good faith, or as Lord Justice Leggett noted in Yam Seng and ITC, it is swimming against the tides in regards to its implementation within the law. As it is not a recognised doctrine within English law, the courts have struggled to find an exact definition, and the courts have largely been assessing what good faith means along with its parameters on the basis of the contractual circumstances and the relevant background situations. In essence, however, the duty of good faith requires honest and fair dealing between parties, acting in line with the common purpose of the contract. This is further reiterated by Lord Bingham in Director General. He describes it to be as fair and open dealing. It is to lay one's cards on the table in another sense, and for parties to act transparently with one another. Although the duty of good faith is not a recognised doctrine in English law, it is not wholly unfamiliar to English lawyers. In fact, within the Consumer Rights Act of 2015, it is stated within that a term is unfair if contrary to the requirement of good faith, it causes a significant imbalance of the parties' rights and obligations under the contract to the detriment of the consumer. This is fundamental as the courts have recognised that they can intervene in order to ensure that a contract is procedurally and substantively fair, in and only in the context of unfair terms. This goes against the roots of classic contract law theory and the freedom to contract, as parties are regarded as to having the power and the unrestricted freedom to determine how their relationship is governed. It is generally respected and valued that the courts will not intervene with the substance of the contract. However, here, in this context, the duty of good faith has allowed the standard of commercial morality and practice to be upheld. Furthermore, in Petromac and Petroleo, it was shown that the courts were accepting of the notion of good faith in a pre-contractual context. So although elements of good faith have been implemented within English contract law, the circumstances in which the duty of good faith can prevail is fairly limited and specific. To further explore the presence of good faith, I'll turn to how the courts have dealt with the concept of good faith in the performance of contracts, namely through express terms and implied terms. In Berkeley Community Villages, it was found that there was a breach in express terms by the defendant. Within Clause 32 of the contract, the parties were required to act with utmost good faith towards one another and act responsibly and prudently at all times. The defendant and claimant had an agreement that the claimant would use their experience to maximise the potential of the defendant's land for development. In return, the claimant was entitled to various fees. The defendant later considered selling off the farm. At this time, the claimant had yet to become entitled to any fees, but had already performed considerable amount of work and enhanced the land's value. To come to the conclusion that the defendant had breached this clause of good faith, Mr. Justice Morgan categorised the principle of good faith on the basis of 3 points with reference to US law. Firstly, to observe reasonable commercial standards of fair dealing, to be faithful with a common purpose, and, finally, to be consistent with the justified expectations of the other contractual party. This undoubtedly echoes what Lord Steyne stated in his article in the LQR, that when dealing with good faith in the law of contract, it should not be feared by the courts, as one is simply dealing with what the reasonable expectations of an honest man would be. A concept that is very familiar amongst common law, and therefore proving that judges can use this concept of good faith with fewer difficulties than anticipated. However, there have been some limitations in this doctrine carrying out its purpose of good faith, as seen within Bristol Rover and Sainsbury's Supermarket. In this case, it was held that where more precise obligations in the contract were held, those would prevail over good faith due to the vague and undefined nature of it. Furthermore, in Mid-Essex, it was held that the express term of good faith could not cut across the contract to terminate it, and it was limited to the clause where it was defined to. Hannett James makes a good point of the court's willingness to give effect to the term, and he's noted that the courts have had a very restrictive lens on this general concept, and this hostility towards the doctrine of good faith boils down to the fact that the English courts are proceeding to adopt a party-centric view by falling back on traditional values and policies. Through non-intervention, the courts are respecting the freedom of contract, however, are consequently encouraging and feeding the idea that parties are in dispute, that when they are in dispute, they are in fact opposing one another, they are against one another, and there is a limited flexibility to salvage legal relationships due to this doctrine not being an overarching general principle in English law in the first place. If this doctrine of good faith, of this duty of good faith were in place, this would eliminate this hostile view parties may have to one another, as both would be in mutual agreement to preserve their interests. A further concern with the doctrine of good faith under English law is that implying a duty of good faith would create too much uncertainty of vague obligations and in turn undermine contractual certainty, something English law places great weight upon. English law, however, has shown implicit evolution towards the recognition of some sort of duty of good faith, and this can be seen in Yam Seng and ITC. In this case, both parties entered into an agreement that granted the claimant rights to distribute Manchester United perfumes. These fragrances were going to be distributed, sold in duty-free shops and airports across the Middle East and Asia. The contract was entered into a short-term period with an agreement to reconvene for negotiation. Later, however, Yam Seng didn't deliver the goods, and ITC then couldn't supply their suppliers. This led ITC to sue Yam Seng for misrepresentation, and the breach of duty of good faith. An important issue, therefore, that had to be decided by Legat was whether a duty of good faith could be implied into the contract. Legat found that to imply the duty of good faith was nothing more than to imply the duty of honesty in fact. He came to this notion by recognising that contracts are made against a background of shared understandings, encompassing matters of facts known by the parties and also shared values, including an expectation of honesty. This therefore presents the idea that if such a principle was implied in all contracts, this would allow parties to confidently enter into a contract without having the fear to be let down or having that sense of safety, knowing that parties wouldn't be dishonest with one another, and this would further discourage parties to breach contracts. So, should English contract law implement the principle of good faith? In light of unforeseen circumstances, such as COVID, adoption of good faith in all contracts undoubtedly would allow for greater flexibility. It would provide a safety net between parties and ultimately minimise legal dispute. The fact that this principle has been increasingly implemented into express and implied terms between businesses seen within contracts, within recent case law and within business contracts, furthermore reflects that British society is striving for this concept. Business parties want to enter contracts knowing that they're on a safe ground, that there can be room for flexibility and cooperation. A blanket implementation of good faith, however, would not be the most effective solution. As Lord Justice Legat suggested, the duty of good faith needs to be grown and implemented on a case-by-case basis. This way it can still keep the underpinning values of contract law. English contract law has already shown to be doing this through the development of numerous piecemeal solutions, such as estoppel and misinterpretation. The incorporation of the duty of good faith doctrine could enhance these tools already in place to solve dispute and limit legal uncertainty. Furthermore, misinterpretation, similar to good faith, is largely context dependent, and it also requires a reasonable test. It is a fairly wide-scope doctrine, much like good faith, and therefore English contract law adopting the principle of good faith is not such a drastic step. Therefore, I would say that it is time for English law to embrace the duty of good faith in performance of all contracts. That does conclude my presentation today. Thank you for your time and attention.